video. Unfortunately, we don't have cameras in the county computers.
Okay. Colin, let me know when the recording started.
The recording has started.
Okay. All right. Good morning, ladies and gentlemen. It's now just a moment after 10 o'clock here on Friday, June the 16th, which was the time and date announced at the initial public hearing for this matter held in May, to which we were continuing this public hearing for purposes of allowing staff to respond to a number of materials and comments that had come in after the staff report was issued or items that were discovered. And staff was given an opportunity to submit a supplement to the staff report addressing all of those issues, which did occur. I did receive a copy of that. And I will note for the record that Mr. Maycock, the staff person responsible for reviewing this matter, he posted the addendum to the staff report on the county's website, and I believe it's been available for some time now for members of the public, interested parties, enters, and the applicant team to review before today. So the purpose of this continuation is to reopen the public hearing for purposes of considering the addendum and staff responses. The process I will follow is I will hear from staff to summarize the key issues in their addendum and their follow-up to the report provided for the hearing in May. And then I will give the applicant an opportunity to respond to that. Submitted any letters or things, reports or anything in response to the addendum of the staff report, that would be the time for them to direct attention to that for me. Then I will open it for comment from members of the public that might be online, parties of record who participated in the May hearing, to respond to anything that is in the addendum to the staff report. I keep emphasizing that because this is not an opportunity to replow ground that was already covered, that is not raised in the staff report, and I could think of 100 examples of that, but if somebody does start to go far afield, I would expect that staff or the applicant make an objection, and I'll rule on it at the time. So the scope of testimony today will be narrow for purposes of covering the addendum to the staff report and any questions I might throw out there on the table. So before we start, to Mr. Maycock, who is online by phone and not video, are there any other procedural issues that staff needs to bring to my attention before we start the substance of the hearing this morning?
I don't believe so.
Okay.
Mr.
All right.
Hearing Examiner, this is Joanna.
Okay.
Mr. Examiner.
I'm sorry.
Thank you. Oh, I apologize, Mr. Examiner. I'm here on behalf of the applicant. I just wanted to let you know that we are not able to see you. Your screen is black and your audio is cutting out a little bit. I'm not having any trouble following you. Oh, there you are. So I just thought I would let the examiner know that. Thank you.
I'm going to count 4. 1, 2, 3, 4. Is that audio quality better?
I heard all numbers.
Okay, without much breakup. Yeah, this computer usually has my Wi-Fi usually has a very good connection, but if you're hearing me blip, 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 if it gets bad, raise your hand. I might sign off and sign back on because sometimes the new connection refreshes it. Yeah, no, I'm going to double check. Hold on just a second. Yeah, sorry, I just wanted to make sure I was signed into my super fast Wi-Fi, and it looks like we are. So if I need to reset it, you're going to let me know because I want everybody to be able to hear. Okay. All right. So Mr. Maycock, if you're ready to move forward, if you would please listen to me. Do you swear or affirm the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth?
I do.
All right, Mr. Maycock, you may proceed.
Okay, so Briefly, the Friends of the San Juan submitted a comment letter on the project on March 14th, 2023, and this comment letter was not included in the staff report, nor were its concerns addressed in the staff report. It was, however, provided to the applicant, which I learned after the fact, and that is addressed in the staff report. The March 14 comments from the Friends focused on four main points. First, the legitimacy of the emergency that the stabilization measure was meant to be abating, the failure of the structure to meet the conditions for stabilizations, primarily there was no threat to a primary structure, and they questioned whether the stabilization was necessary to protect from erosion. And the other one was a question about an assertion that the applicants failed to properly, adequately evaluate the impacts of the stabilization structure. There was two memos. In addition to the comment letters, there was a March 8th memo from Ms. Whitman, which was addressed in the staff report, and then there was an additional memo from Ms. Whitman that hadn't been addressed in the May 14th staff report. In the response, as laid out in the addendum, is that the application is for an after-the-fact permit to legitimize the unpermitted construction of the shoreline stabilization measure. As we've shown, San Juan County Code sections 1850 100D, 1850 110E5, and 1850 35F3 allow for the construction of hard armoring to protect archaeological resources. And just procedurally, an after-the-fact permit review proceeds as if the project hadn't been completed, and so the application was reviewed in relation to the then existing regulations at the time, to determine whether or not it was consistent with the code. Ultimately, as laid out in the May 2nd staff report, May 14th staff report, sorry, the application was deemed to be consistent with the county code insofar as it was protecting cultural resources, and that was authorized at the time. There was credible evidence provided by the applicant and the third party that the hard stabilization was necessary to stabilize the bank. Multiple exhibits, 1C, 1L, 1LA, 1P, and 1X, identify and analyze the impacts of the structure. There was a question about whether the location or the site of the stabilization is in fact a pocket beach. There was questions and evidence presented by Andrea McLennan, and in the March 14th comments, asserting that it was a pocket beach. Equally, there was a geotech report issued by the applicant that indicates that it's not a pocket beach. The county recognizes that the experts can disagree on the existing conditions. Also addressed in the staff report is that the county recommends changes to permit condition number 6 that was included in the original May 14th staff report, and so it provides alternate language to that, and also recommends that the hearing examiner consider a condition that directs the applicant to remove the rocks that are below the ordinary high water mark. That concludes my presentation.
Okay. And one thing I didn't mention, I think I told you all in May that I plan to do a site visit. I actually have done a site visit to the property. I walked down on the side of the house and walked down and hopped down onto the beach itself and walked, I guess that would be north and south to get an idea of what things look like. And I saw the wall materials that it looked like it would be made of. Spent a couple of months down there, and I tried to identify things that were mentioned during the hearing. And one thing I did see is a very large remnant of what was, to my knowledge, a really big madrona tree that was down there right on the shoreline, or maybe a few feet uphill from where the high tide might hit. It was a lower tide when I was there. It was out quite a ways. So commenting on, where the water hits things, didn't see that. But I just wanted it on the record that I have done a site visit. So I have an appreciation for what's there. Okay, now would be an opportunity for the applicant team to respond to the new information that's come forward from staff this morning. And Ms. Koloshkova or Ms. Shaw, which of you is the team leader today?
Good morning.
For the
Good morning, Mr. Hearing Examiner Duana Koloshkova here. And I want to thank you for setting the stage as to the context of this hearing being a continued hearing, and we understand that the comments which were previously made at the prior open record hearing are, it is as if we were just continuing with those comments, so no need to reiterate testimony related to those matters here today. And we'd also like to confirm with the examiner that this is not an opportunity to open the matter up to discussion of issues that have either not been raised to date or other matters. Again, continued hearing being that material that the staff report covered in response to the inadvertently omitted comment letters in the original staff report. I think the examiner covered that. We just have a few short comments from a couple of our experts, although our team in its entirety is here also to answer questions and respond to any public comments if needs be. Ultimately, we do ask the hearing examiner to approve the application, supporting that the county has correctly acknowledged that the structure should be approved in its current location and configuration with the amended condition number 6. And we would also ask the hearing examiner, based on the forthcoming testimony, not to condition the project on any removal of the small rocks that are necessary to sustain the structure, as you'll hear testimony on in a moment. The individuals that we would like to have provide follow-up comment are Francine Shaw, Ed Kilduff, Glenn Maurer, and Don Klein, who represents the ownership group of this property. Everybody's just got a real short piece to share based on the amended staff report. So if we can just go in that order, I can mostly keep my mic off if that's an easier flow. And with that, I'll turn it over to Francine. I don't see her on the screen, but she may well be, might be my own screen limitations. Thank you.
I see her. Okay.
Hi.
Ms. Shaw, do you swear or affirm the testimony you're about to give this morning is the truth, the whole truth, and nothing but the truth?
I certainly do.
The floor is yours.
All right. So yes, I have just a brief little bit of a presentation. One of it, although it has not come up as a condition of approval, is the idea of adding beach nourishment to this property. We know that it has suitable spawning habitat on it. We've conducted 2 beach material studies within the last year. And our biologist, Grant Novak, has determined that the beach sediment meets spawning habitat. Now, the structure that we're trying to permit today has been in place for over 3.5 years. And if there is going to be any starvation of the beach by preventing the bank material from reaching the beach, we would probably have seen evidence of that by now. And there simply is no evidence. So that's kind of, I just want to put that out there, that we don't need beach nourishment because this beach is just fine for spawning habitat. I have 2 other things I'd like to do. I'd like to correct the record in the staff report. Colin talks about an emergency structure being not being permitted at 66 Tagney Memorial Drive, which is also in the ownership of this family. And that is simply not true. I did send Colin an email on June 13th, Tuesday, which verified that in fact we did permit that structure correctly. And I don't want my client to have that bad, look bad because of that. We did apply for a shoreline exemption at 66 Tagney Memorial Drive, and it was in and it was being processed. And during that time, we hired Coastal Geologic Services to come out, and they looked at it, and we had a structural engineer out, and we were having problems with the structural members of a seaward deck twisting. And so there was some structural damage going on. And so I asked Ms. Shook, who was the director at that time, if we could in fact build an emergency structure. And in fact, she said yes. And I did provide all that documentation to Colin on Tuesday. And one thing, it's not a big thing, but in the staff report under critical areas, it says the parcel is within an archaeological buffer. We know that it's an archaeological site. And this goes back into the late 90s when Mr. Klein built his main residence on the property, and he had to do an archaeological study, and middens were found then, and he was required to protect them. And then again, we did an archaeological study for this particular property and permit, and yes, we found middens there. So maybe the county and the Department of Archaeology and Historic Preservation should update their database to say that this is a site and not a buffer. And that concludes my presentation.
Thank you, Ms. Shaw. Appreciate that.
You're welcome.
Okay, and whoever was next, if you want to turn on your microphone and raise your right hand.
Mr. Kilduff.
Mr. Kilduff. Mr. Kilduff, do you swear or affirm the testimony you're about to give this morning will be the truth, the whole truth, and nothing but the truth?
I do.
You may proceed.
Yes, thank you. I just want to make a few comments about the comment about removing the toe stones. The toe stones, in my opinion, my professional opinion, are integral to the performance of the structure itself, the wall itself. And this goes back to an issue that's already been talked about quite a bit, which is scour. And so the toe stones help address the issue of scour. And I think the fact that there's been deposition and a grading of the beach in that area sort of points to their effectiveness. And I did go out to the site yesterday and took another look. And the toe stones are almost integral now with the vegetation in the beach itself. So we feel the toe stones are playing an important role in making sure that the beach continues to grade and deposit. And I also want to just cite that there is a section in the state's marine shorelines design guidelines about armor stone toe protection. And it's quite long. It's about a paragraph, but I'll just read the first part of it, which says that armor stones are sometimes placed waterward of the exposed toe of bulkheads to combat scour and enhance structural integrity. And that's essentially the role that they're playing here. And I think they're doing it very effectively. And that concludes my presentation.
And just to be perfectly clear, Mr. Kilduff, you referred to toe stones, and I don't remember everybody calling it that the last time. These are the sharp-edged rocks, which, because I've done a site visit, they probably range in size from maybe like 4 inches to maybe some might be 9 inches, and I don't know. They look like, I mean, they're big rocks, but they're sharp. They look like they're broken. I don't know. Exactly. Are they broken pieces of granite? What are they?
There's very little granite here in Washington State, so they're probably they look like some sort of I'm trying to, how do I describe it without using too many geology terms? They look like the sort of volcanic end of granite. Yes, but that's essentially right. Not to get too technical. They're
fine. The one thing I will note for the record that they do. If you were to ask me, one of these things doesn't look like the others. And if you
Mhm.
look at the beach environment, they really stand out.
Yeah.
And your comment about things are being integrated into the system or something to that effect, and not yet. If that means they're getting covered by more sand and cobble and things like that, well, no, they really stand out. And if I was somebody to look at it from an aesthetic point of view, I would say it's probably the ugliest part of the project
Well,
when you look at it from the beach.
Well, yeah, I also make a distinction between 54 and 66. I agree with you that along some parts of the beach there, they're standing out, and in other parts, they're more incorporated into the vegetation.
Which one is north of which? 66 or 54? Which is north of the other?
It looks like to me, it looks like 54 is more sort of integrated already into the beach, and 66 is not.
I'm sorry, I needed to know which is which. So if I'm standing on the beach and I'm looking at 54 and 56, and I'm looking at the properties, which
Yeah.
one's on my left? Which one's on my right?
54 is on the left, 66 is on the right.
Thank you.
You're welcome.
And you said you believe it's more integrated.
Along
which one?
Along 54 than 66.
Thank you.
You're welcome.
All right, and who was next?
Mr. Maurer?
Okay, Mr. Maurer. Do you swear or affirm that testimony you're about to give today will be the truth, the whole truth, and nothing but the truth? Nothing but the truth. Sorry. Okay. You may proceed.
Good morning, Mr. Examiner. Thank you for the opportunity to speak. I'm going to share with you a picture that I shared with you during the hearing. And that shows the current condition of the property that you had recently walked. On your screen is a picture taken Saturday, May 20th of the beach in front of 54 Tangy Memorial Drive. It was presented during the comment period that I spoke at on May 24th. I'd like to follow up on comments made this morning by Mr. Kilda regarding the tow rock placed along the bank. As he mentioned, the rock supports the MC armoring by dampening wave energy and eliminating tow scour and it also protects the MC bags from driftwood. There have been comments made that the rock is migrating to the beach. As you can see from the pictures, there is naturally placed rock on the beach. The rock is not migrating onto the beach. If a decision is made to remove the rock, I want to stress that there will be negative impacts to the beach, the bank, and the existing vegetation. The benefits provided by the rock, such as protection from tow scouring and dampened wave energy, will be lost. Vegetation in front of the rock and vegetation growing amongst the rock will be impacted. During the removal process, the beach will be impacted as rock is transported seaward to a barge or upland to a truck for transport to a licensed permitted landfill. The area would be damaged during the work, including damage to the now mature vegetation. It is our hope that the benefits provided by the rock are valued and any final decision will allow for its retention. However, if it doesn't, I just wanted to stress that there will be short-term and long-term impacts resulting from its removal. Thank you, Your Honor, for your time and consideration.
Thank you, Mr. Maurer, and you can probably stop screen sharing there. Mr. Examiner, I believe you're on mute if you were trying to speak. Our next witness would be Mr. Klein, unless there were questions for Mr. Maurer.
My Ring doorbell was bothering everybody, so I had to turn off the mute. Or yeah, there we go. Sorry about that. Did you say Mr. Lynch was next?
Mr. Klein and Mr. Maurer, can you stop screen sharing as well, please?
Yes, I'm in the process right now.
And where
Thanks.
is Mr. Klein? I don't see Mr. Klein listed.
He is in the conference room with Mr. James Lynch. There we go.
Oh, I see Lynch at the bottom. Okay. So, Mr. Klein, would you wave your hand? You are? Okay. Mr. Klein, now that your hand's up, do you swear or affirm that testimony you're about to give today will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. And Mr. Klein, you weren't here for the first day of hearing, or were you?
I was, but I lost internet connection, so I missed a large portion of that.
Okay, that might be why I didn't acknowledge that you were there. So my apologies. Okay. All right, Mr. Klein, the floor is.
Okay, in the 4.5 years that this has been going on, the property has been continuously posted, and there's a large amount of traffic by the house on the roadside, just as there's a large amount of traffic on the water side. And in that time, there's been no adverse comment. In fact, no comment at all by anyone other than the Friends of the San Juan. So I have spoken to
Mr.
neighbors.
Klein, hold on just for a second. There we go.
Yes.
The screen share went away. I can see you
Okay.
better now. That's better. So you may proceed.
Okay.
Keep going.
All right. So anyway, we haven't had any comment really about what we've done other than the comments from the Friends of the San Juan. But I have a short summary that I'd like to read into the hearing if I could. And a copy of this has been provided to Mr. Maycock to submit into the record as well. So with your permission, I'll
do the supplement to the staff report. Absolutely.
So may I read it then?
If it's brief, you can. Otherwise,
Yes.
I'd prefer it.
Okay, as I said at the previous hearing, I lost my internet connection, missed a portion. And that of a hearing that was 4.5 years in the making. And now I'd like to read this into the record, the following statement that I will also send in for the record through Mr. Maycock. My family and I have lived on the property for over 40 years. The prior owner lived in a small house on one of the lots for 50 years. Earlier, a narrow gauge railway ran from the resort to docks that were on this and adjoining property that load brick and lime products from the kilns at the resort on ships shown in the picture on this page. Rotted remains of the piers from this historical activity are still on the beach in front of the houses. Cultural remains within the Midden were discovered and dated when the houses were built over 30 years ago and determined to be approximately 1,200 years old. In the over 40 years that I've lived there, I've seen the damaging changes to the beach. During this time, the beach has lost over 3 feet of sand and gravel from tides and storms, slowly at first, but then accelerating from the higher tides and more severe storms resulting from climate change. This is happening all over the world and is in the paper every day. When we built the houses in the 90s, we were required to study the property for lamination cultural remains, and once confirmed, required to protect them. The subsequent failure of the bank and landslide threatened the Midden and the utilities and the houses. History, on-site observation, and common sense said the bank needed to be stabilized to protect the Middens, the utilities, and the houses. This had to be done without delay as the bank failure was continuing, and an unsupported cavity was found below the recent slide. I contacted the county and asked for an emergency permit to protect the bank. I was denied. San Juan County at the hearing stated we had qualified for a substantial development permit, yet now 4.5 years later, we're still trying to get it. To protect the bank, Middens, and property, I chose to construct the arm room. Without immediate action, the failure would have continued, the cavity would have collapsed, the apple tree would have fallen onto the beach, and the bank vegetation and Middens would have been lost. Instead, with a great team of consultants and hard labor, what we achieved is an amazing result that protects and preserves the natural condition of the bank and everything behind it. Grasses that have been on the beach for decades before the landslide were largely destroyed. We replaced damaged grasses and placed tow rock at the base of the bank to prevent undercutting the base and destabilizing the bags, and to dampen reflective wave energy and prevent scouring to the beach. The result is that a beach that I personally observed was down to hardband has rebuilt itself with 4 to 6 inches of sand and gravels. This tow rock remains in place and is not migrating to the beach. All of the above was communicated to the county and the Friends of the San Juan. I personally went to the offices of the Friends of the San Juan and met with Tina Whitman and asked for her advice on what would improve on what we had done. She was not interested in talking or recommending anything. Later, one of her legal staff, when asked this same thing again, said, let it wash into the harbor, even though they knew there were cultural remains on the property that needed to be protected. In the hearing, the Friends of the San Juan have requested beach nourishment, even though it's not a pocket beach, gets no nourishment from upland properties, and is not a spawning beach as acknowledged by the Washington State Fish and Wildlife and supported by our extensive biological study. All the beach sand and gravels that are continuing to build are coming from the water side. The beach is continuing to rebuild itself. There is no need to bring in additional beach nourishment. The county has been bullied forever by Tina Whitman and her friends, and it's known throughout the island that the Friends of the San Juan will financially destroy you if you try anything without their blessing. This has to change. The county needs to act to support the shoreline property owners as they face a more violent and changing climate and its damage to the shoreline. This project qualified for a substantial development permit 4.5 years ago, and I ask that the permit finally be issued to validate the work that is in place today. Thank you for listening to me.
Thank you, sir. Ms. Koloshkova, anybody else for the applicant team?
Thank you, Mr. Examiner. That is it. Again, we have our entire team available, and I would reserve the ability to respond to public comments. I did provide, legal support for the application at the original hearing on this. So I would hearken back to my comments there and otherwise request again that the examiner accept the revised language for condition number 6, and as well that the examiner approve the project as it has been applied for and exists today based on the testimony, particularly with respect to the evidentiary comments that Ms. Shaw, Mr. Kilduff, and Mr. Maurer had talked about, as well as the history from Mr. Klein. We thank you, Mr. Examiner, and we'll pick it up after public comment.
I'll save my question then for after public comments. Okay. All right. So are there any people online who are parties of record during the initial hearing who wish to offer comments regarding the supplement to the staff report? I see Mr. McCubbin has the little hand symbol up. So Mr. McCubbin, I recognize you from being a participant in the last day of the hearing. So if you would please, are you going to be testifying on fact evidence, or are you speaking as an attorney?
As an attorney without fact evidence. Thank you, Mr. Examiner.
You may proceed.
Thank you. I want to thank you, Mr. Examiner, for continuing this, and to County staff Colin Maycock for going back and amending the staff report and including those materials that were inadvertently overlooked. I realize that created a procedural sort of nightmare here, and I do understand it was inadvertent, so I appreciate addressing those matters. I also appreciate Colin's report really clarifying where the high water mark is on this property. And Mr. Hearing Examiner, you probably observed that the beach line goes up above where this the rock that we're now referring to today is the toe rock. The beach goes up above that, and we now know from the updated staff report that the high water mark is above all of that rock, which of course also means that the bottom of the geotextile bags is also below the high water mark on the property. That's been unclear throughout the applications in this. We've had repeated SEPA proceedings because the high water mark had not been clarified. And a lot of those delays, I would submit, are due to the inconsistency in reporting by the application materials. So I appreciate Colin clarifying that in this final report. I also appreciate including the WDFW comments, and I think those are really important. And also in combination with Ms. Shaw's comments today, acknowledging that this beach is appropriate spawning habitat for feeder fish, if you will, for supporting fish that are critical to support salmon in our Salish Sea environment, which of course in turn support the endangered southern resident killer whales. As noted by WDFW, there is no habitat or structural function to that tow rock. And that commentary is consistent with the comments that we have that you received both verbally, and now you have the report from Andrea McLennan, and you also received the report from Jessica Cote. So there's ample, factual support here to show that this is not necessary rock on the beach, and those rocks necessarily block the spawning habitat. You can't have fish eggs where there's a large rock sitting there. It just doesn't work to have both. So the acknowledged fish spawning habitat is interfered with by the presence of that rock. We know from Ms. Cote and from Ms. McLennan that there simply is not enough wave energy here to really put the geotextile bags at risk without the rock present. I'll reiterate that out of respect for the comments from the Lummi Nation, Friends of the San Juans is not asking for removal of the geotextile bags at this point. Under the current regulations, this whole permit would not be allowed, but we acknowledge the regulations that were in place that are applicable for this sort of after the fact excuse, if you will, to put in this structure as protection of archaeological resources. But the law and the regulations that are effective do support that. So we're not challenging that. But absolutely, we think that you should follow the recommendations of WDFW and the staff report and require removal of that tow rock, which is interfering with the acknowledged spawning habitat and which is entirely below the high water mark on this property. And also, as noted by WDFW, which is an accurate citation, the WAC provision that they cited, 220-660-370, 3A, I believe it is, requires that the efforts used for this type of permit must be the least impactful available to address the problems. And that here would be the geotextile bags and does not include the rock that's on the beach. So we would encourage you to go ahead, adopt the amended permit condition number 6 as proposed, which doesn't sound like there's any dispute over that, and also adopt a condition requiring that the rock that has been placed below the high water mark on the beach be removed. We would also ask that staff be required to follow up with an inspection to confirm that that has been done, given the inconsistent reporting and history of the applicant going ahead with this project when told that there was not an emergency by the county. So I think that an inspection to confirm that the conditions have been met really is critical for this application. Thank you.
Okay, thanks, Mr. McCubbin. Are there any other speakers that would like to comment regarding on the matter? If you would hit your little hand symbol.
Mr. McLean, I'm sorry, may I respond separately to some comments made by Mr. Klein, just to clarify that I have not had any contact with him. I don't know what he was referencing in terms of contact with legal counsel, but I'm not aware of anyone on the Friends legal team or prior legal team having had contact with him. I know he is represented by counsel, so I just did want to address that quickly. Thank you.
Okay, all right, thank you. All right, are there any other people online who want to offer comments regarding this matter? If you're online on the Teams platform, use the little hand symbol. I don't see anybody popping up. Let me make sure. Mr. Maycock, do you see anybody I'm missing? And are there any people that may have phoned in who don't appear here on my list that want to offer comments? If so, unmute your microphone and introduce yourself if you'd like to offer a comment. Anybody? Okay. Last call for public comments. Unmute your microphone and say hello, and I'll get your name and let you speak. Seeing no one. Mr. Maycock, did you receive calls from anybody, or have you received any emails from people breathlessly telling you they had a hard time signing in? How do I get in? I need 5 more minutes, anything to that effect? Mr. Maycock, your device is on mute. Colin, I can't hear you if you're trying to talk. I assume you're there. Could you unmute your microphone and respond?
Mr. Examiner, I'm seeing that there are chat notes in the box that Mr. Maycock is trying to unmute his mic.
I make a record. We do some. Okay. I usually like to shut down. Okay.
All right. Sorry about that. I hit the wrong button and the world exploded. So I guess I just have a couple of responses. First, that
Well, Mr. Maycock, stop. I asked, and you have heard my question. I'm asking you, have you received contact from anyone by email or phone today, or that this morning have reached out to you or other staff near you saying they're having trouble signing in?
No.
Okay. And did you receive a ping from anybody saying they're trying to speak and I haven't recognized that?
No.
All right. And I don't see anything. I'll confirm that on the record. And I've done last call a few times, so I will close the public comment portion of the public hearing. And now we can move on to responses. Mr. Maycock, if you want to go first, you can. And then I'll turn to the applicant team to provide their responses.
Sure. So one comment regarding the cultural resources buffer, because this is a public document and we're not supposed to reveal the location of archaeological sites to the public. I mean, it's restricted information since it's not generally available. We don't refer to archaeological sites in our staff report as a matter of course. We refer to archaeological buffers because we don't want to give people the information where they might want to go dig. So that would be one issue. Another issue is, while I recognize that the stabilization measure on the neighboring parcel was going through the process, the fact that an emergency authorization to build the structure was offered prior to the proper formal permit was being issued it's still an after the fact permit, which is what I referred to it as. But I'm willing to concede that in fact it was an exemption, which is in itself not itself a permit. It's in fact an exemption from a permit. So I recognize that and I'm comfortable with the correction. With regards to I mean, I think the issues regarding the tow rock can be evaluated. There's obviously experts on either side of that, and I'll request that the hearing examiner makes the decision on that point. And I don't really think I have any other issues. I mean, no, I don't have any other additional responses.
And just to clarify, this permit pertains to one of the two properties, not both, correct?
Correct. This is for 54 Tagney Memorial Drive. The permit or the exemption that was sought for 66 to the neighboring parcel was approved in June 2020, I believe.
Okay. Just wanted it clear on the record. I'm not amending something else. This is a standalone for 54 Tangy. Yeah. Okay. Mr. Maycock, did you confer with anybody from WDFW beyond what is in the record?
No, I talked briefly to
Or did-
Beth Tate.
You.
Sorry, what was that?
Go ahead. Go ahead and respond.
So I called Alex Richard, who was the commenter, who then referred me to Elizabeth Tate. So I talked to her briefly about that comment, and I mean largely about the fact that there's no option in an HPA to issue an after the fact HPA for a project.
Okay. And on the subject of additional nourishment, you recommended that I consider a condition removing the toe rock, as it's been called today. What are your thoughts regarding the nourishment that the friends have suggested, and the applicant experts, or said the applicant witnesses say it's not necessary?
I would say that there's not enough evidence in the record to support the claim that it's a pocket beach. And so I'm not sure that the impoundment of sediment from the landward side of the structure is going to be a significant determination of whether or not there's scour there. I think the issue about the forage fish spawning habitat and the fact that it's covered up is a separate issue. So I would say that I don't see enough evidence to support the requirement for additional beach nourishment. However, this is a low energy beachfront. It's apparently a low energy beachfront, and it's not apparent that there's a structural purpose to this beach rock other than it is a revetment that dissipates wave energy. However, there isn't a lot of wave energy, and so I don't know if it's really that necessary. Obviously, there is a dispute there amongst experts who say, some who say it is, others who say it isn't.
Okay. All right. Hold on there, because you might have to address some other disclosures. Seshkova, I turn to you and the applicant team. How would you like to respond to comments?
Thank you, Mr. Examiner. Oh, pardon me.
Before you go, I'm going to go ahead and throw my question on the table, which I saved till after comments for you. Because the comment on removing what's been labeled the toe rocks came forward and was on the table, and it was a suggestion by the state agency, Fish and Wildlife, WDFW. That's a state agency that weighs in on a lot of projects. And I understand if I were to approve this permit, it would then go forward to the Shorelines Board or a filing with the Department of Ecology. An appeal is always possible. And I'm just saying, mindful that a state agency may have a basis or based on their position they've taken. If I left that out as a condition, you're mindful that an appeal could easily come forward. Not saying I'm just creating a hypothetical, but you're fully informed on that, and does that not concern you?
Mr. Examiner, I guess I would say that we're asking for the permit as it is appropriately approved under county code and within the hearing examiner's jurisdiction. I would say as a matter of policy, we don't ask the examiner to issue, decisions on the concern of whether an appeal might be filed or not, from the standpoint that we wouldn't know whether there would be any merit to an appeal. I do believe it's appropriate to hear from Ms. Shaw and Mr. Kilduff in response to the comments on the tow rock. And there may be room to look at the issue differently as the matter winds its way through regulatory review. But at this point in time, we believe the evidence is quite solid in support of the application as it's been submitted today. So I hope that answers your question. I'm happy to revisit it, but I would like the opportunity for my expert witnesses to respond on the topics that have been presented, and particularly the utility of that tow rock as well. I'll start with Ms. Shaw, if you're ready to go.
I am. I did take some notes during the discussion. And first of all, there is no San Juan County code that prohibits a shoreline stabilization structure from going seaward of the ordinary high water mark. What we have to show is a no net loss, which we have done through our many biological reports. And this is not to be disrespectful, but WDFW is a biological type of a agency, and they are not structural engineers. To say that the tow rock is not structural, just would like to put that on the record. Wave energy, here's something that has never really been discussed, that typically the wave energy is pretty low here, but when you start adding in the boat traffic from Roche Harbor Marina, which goes right by this property, those waves get pretty strong, and it can have some impact to that shoreline. And I just like to bring that up. But that's basically my issues that I'd like to put back into the record based on comments that I've heard.
Mrs. Shaw, personal experience in Roche Harbor, is there a report that indicates that wave energy in this place is a real concern beyond what it might be somewhere else? Based on, I mean, we've got dueling experts on the pocket beach issue. One saying it's not a pocket beach, so nourishment isn't a problem. The other saying, well, it is. Things come and go. And is there something that I don't know, uses your statement about wave energy coming from the nature of the marina and all the large boats that pass? How does that impact your request for a permit that authorizes this with the tow rock? And is there a study or a report in there that mentioned that? Or is this the first time I'm hearing that?
I would have to defer to our geologist and our civil engineer. One thing that I would like to put on the record, though, is that the county's third-party geotech engineer saw the structure with the tow rock and had no issue with the tow rock, and has not stated, and which we would have hoped the county would have went back to their geologist to say, if we remove this tow rock, what will it do structurally? And they did not do that. So as it stands, the county's own third-party geotech engineer reviewed the structure for structural stability and did not have any comment that the tow rock was not necessary.
Okay, thanks, Ms. Shaw.
You're welcome.
Right. Was there? Thank you. Was Mr. Kilduff gonna?
Yeah,
go ahead, Mr. Kilduff.
Add a couple of brief comments that it's sometimes often difficult to sort of back calculate what the wave energies and things like that might be, and I operate more on sort of an empirical basis about what is the grain sizes of the beach and how do they get there, and what does that tell us about the currents that may be there. And the grain sizes would tell us that regardless of what calculation for fetch and other things might be, that somehow a combination of boat waves or tides and something else is large enough to move some fairly large grain sizes and grade them on the beach. The other thing I'd point out is that I think we don't have to prejudge or guess about what performance of the structure has been relative to nothing, because I think you've got a demonstration and an example of that, just as Mr. Hearing Examiner mentioned, the Madrona just south of the subject properties, and a little bit of slide associated with that. I think that's good evidence of something that was not protected, and over the same amount of time has now been eroded by whatever waves and energies are there. And there was another point that I was going to make, but those are the two main points. But and the toe rocks, I think, are that's the other point I want to make. I have heard, not on this case, but on other cases, WDFW makes similar comments about pointy rocks and about toe rocks and things like that. And when I have pressed them on that, it seems to be the same kind of observation that you made, Mr. Examiner, that aesthetically they don't particularly like them. But I haven't heard any kind of structural issue like Ms. Shaw was saying about whether the toe rocks are effective. It seems to be more appearance than anything else.
So, Mr. Kilduff, and I'm sorry, your structural, what's your
field? So I'm
an
engineering geologist, which basically is the interplay of geology with the built environment, as well as a hydrogeologist.
Okay, you've been in front of me in other applications before, and sometimes you're asked to wear a hat in one specialist field and one in another, but they're usually about geo and hydrology. Okay, all right. So you're the right one to ask the question. And I appreciate the testimony that the toe rocks provide support and things of that sort. I understand that. That testimony anyway. Not saying that, anyway, I understand the testimony on that topic. But on the subject of nourishment, in other applications I've dealt with in other places, not here, sometimes it's a requirement where hard armoring is put in that nourishment's required over a period of time going forward, say maybe 4 or 5 years forward. And I just know that washed rock that's high quality, soft rock, pretty little cobblestones, that's what I'll call it, are poured out right up against it. And everybody knows that it's going to wash away and migrate, into the beach eventually, but it provides some stability. And I guess it's there in some contexts. It's happened because fish like smooth rock surfaces better than they like pointy things, as you said. Mm-hmm. And the last day involved a lot of comment about sharp edged rocks and things. So those pointy rocks may be more unfriendly to a fish than smooth rocks. So having, with that horrible windup the pitch would be, would it ever be of structural benefit to put nourishment like soft rocks on top of those toe rocks? To be, yes, the toe rocks are there, but they're covered with smooth rocks. So if fish want to come up on it, they're not afraid of the sharp edges.
No, I actually think that's a very good question, Mr. Examiner, because because I operate a lot on grain sizes and what are the grain sizes that are actually moved by the currents there and things like that, I have come up with the same thought in that you could, effectively revet or protect something by just having a grain size which is slightly larger than the maximum grain size moved or deposited by the beach. And so I think that's I think the answer to your question is yes. I mean, if you wanted to, for aesthetic reasons only, not structural reasons or anything like that, put pea gravel, for instance, or something like that on top of the pointy rocks, that would be an additional reinforcement, kind of act like tiny little toe stones. You could do that if the aesthetic appearance was the big concern about the appearance of those rocks. But I don't think it would be necessarily a good substitute or anything like that for the rocks themselves, because I think those rocks.
So let's just take it two ways, but that wasn't my question. I'll just get your answer to it. Would would smooth pea gravel, replacing the pointy edged rocks that are there now, would it provide the same level of structural support? Yes or no?
No.
Okay. And moving on, you were talking about if you integrated the two, if you poured pea gravel over the pointy rocks, would that add an extra level of integrity, structural integrity for the wall?
Not really. I don't think so. I think it would primarily be an aesthetic thing, and it wouldn't hurt. It wouldn't
Just-
hurt. No, it wouldn't hurt. No.
Yeah, I hear you. Okay. All right. All right. Okay. Anything else?
No, nothing. Thank you.
Ms. Koloshkova, anybody else in anything else from the applicant team?
Mr. Examiner, not necessarily, so long as we are reminded of the prior testimony that's already on the record. As in the last hearing, we talked, for example, a fair bit, the experts talked a fair bit about fish habitat, and testimony that I believe was pretty conclusive from our team that there is no fish forage habitat out there and no regulatory standard for something like a potential for habitat. There's testimony on the record regarding that. There's also testimony on the record regarding there being a no net loss in this circumstance. So I can bring our witnesses forward to address those topics further if the examiner wishes, or we will rely on the record as that was talked about a fair bit in the original hearing.
I didn't hear a contest on that again today, Ms.
Thank you.
Koloshkova, so I think that would be repeating stuff. So,
Thank
and Mr. Maycock, I didn't turn to you. I asked questions. Does staff have any additional response to any of the questions that I posed or information that the applicants brought forward so far?
No, I have a quick procedural one. There was a request to update the exhibit list to include the Klein comment from this morning. So I'm assuming at this point I should do that, send it out to all the respondents at this point before sending it on to you. So it's just a procedural question.
Mr. Klein has sent in his written comment. If you just put it in as the next number to be exhibit, just update that and send me a PDF copy. That would be helpful. Yeah.
Sure.
And he read it into the record. And Mr. McCubbin, I recognize that you felt the need to respond, and I heard your response. He didn't mention you by name, but he mentioned legal representative or something to that effect. And I take your response, Mr. McCubbin, as an officer of the court. I appreciate and respect your response. Okay, thank you for doing that. All right. Anything else, Mr. Maycock?
I guess I would just point out that when the county hired a third-party review of the applicant's submitted geological material, this was in relation to a different application, in the sense of the original application was to remove what is now the existing structure and to build a bigger one with two-man rocks at the base. And there was one of the geological studies that had been done by the applicant said there was an unsatisfactory safety factor. And the third-party reviewer found that statement wasn't necessarily correct, or it wasn't consistent with the state guidelines. And so the applicant, in response to the third-party review, amended their application to, instead of producing a bigger structure, is to just have the application for the existing structure now. So while the third party, that's it.
Became clearly a project intended for the or protect cultural resources. I don't believe that was the initial application. Am I wrong?
The initial application was the original consultant or consultation in December 2018, January 2019. I don't recall, this was a verbal conversation followed up by an email. I don't recall there was any discussion about cultural resources. It was a question of protecting a
house.
I want to say a platform or a deck, and there was a utility line that had been revealed, and these voids had been revealed. And that was the discussion, the original discussion that the county responded to in an email in early January 2019. But as the project went forward, the cultural resources were further discussed.
Okay. Mr. Maycock, would you direct my attention to any materials in the record, reports or studies of your recommendation is that I consider the request to remove the tow rocks as a condition of approval, but and the nourishment request was also made. But what about leaving tow rocks and putting nourishment atop the tow rocks?
I don't believe that. I mean, leaving the tow rocks has certainly been discussed, or hasn't. Certainly, removing them hasn't been prior till now. I don't believe there's been any comments about adding smaller rocks to the tow rocks. The comments on recommending removal would include, I mean, the WDFW comments on March 8th, which is Exhibit 5N, and then you'd have the hearing comments from Tina Whitman, Jessica Cote, and Andrea McLennan, and you'd also have their written, formally written documents. So that would be the March 14th comment letter, which included Andrea McLennan, the Exhibit 5J, which was Exhibit 5K, which included the comments from Ms. Cote, which again you'd heard from in the hearing.
Anything else?
No, that's it.
Okay. Well, because the applicant gets the last word, Ms. Koloshkova, do you have anything further?
I think you've heard my comments sort of scattered throughout this hearing. We would ask the examiner approve the application. We preserve our comments that we made in the original hearing, particularly also with respect to this discussion of the purposes of the work and our position in terms of the needfulness of it, not just for archaeological protection, but also as an emergency action. I'm not going to get into it. We talked all about it on the second, or pardon me, our prior hearing in May, getting my dates confused there. So we would ask the hearing examiner to approve the project without any sort of additional requirement for either beach nourishment or without requirement to make changes to the tow rocks or the structure as it is stable today. I believe the testimony pretty firmly supports that from the engineering and geotechnical standpoint, both from the concept of no net loss or impacts to the environment, and from the needfulness in order to protect the structure as it is in place today. Thank you, Mr. Examiner, and I think that concludes my comments.
Okay. Well, this is one where it's fair to say everybody's not in full agreement. They don't have to be, but folks are in agreement on some things. And so I have a lot of complicated reports to review, and in the meantime, just let you all know I will review it and I will take it all under advisement. And if I have any questions, I'll let Mr. Maycock know, because sometimes questions come up when you dive into a chart that just got thrown in front of me, and when you're reading it intensely, wow, I should have asked this. I might do that, and I would have him send those questions to you, Ms. Koloshkova, and you could have, if I need to have any clarification on that, I'll let you know. But otherwise, I will take it under advisement, and I will issue a written decision on this matter as soon as possible. And if there was no other business, I will close the hearing on this matter. And thank you all for your participation on this platform, and I hope you were able to hear me.
Mr.
Ms. Koloshkova, did you?
Just curious if there is a timeline for decision making in this one at all, or if the examiner has an expectation, just so that we know when we should anticipate a decision.
Sometime in July, but I'm not going to give you a date. No. There have been a lot of shoreline applications that are under review and this is one where I will say this, they're not waiting to build something. They're just hoping to get a box check that everything gets to stay. And if it does, what else do we have to do? Remove a little bit or put something else in? So anyway, don't mean to say it, but the house isn't on fire.
No, thank you very much. Just making sure that we sort of are all on the same page and not pestering you.
Okay. All right. Thank you very much. The hearing's closed. You all have a wonderful weekend coming up, and take care. We're adjourned.
Thank you, Mr. Examiner.
Thank you.
Thank you very much. Bye-bye.
Thank you.